Son of deceased can be truthful witness. Supreme Court upholds murder conviction despite FIR delay. The Supreme Court has reiterated that a witness' familial relationship with the deceased cannot be the sole ground to discredit their testimony, observing that interested and truthful are two distinct concepts in law. A bench comprising Justices Sanjay Karol and Satish Chandra Sharma dismissed the appeal filed by Nitin Bitto Bintu, challenging the Punjab and Haryana High Court's judgment dated March 13, 2014, which had affirmed his conviction under Section 302 of the Indian Penal Code for the murder of Gurmeet Kaur. The case arose from an FIR registered on August 30, 2008. While the trial court, in its judgment dated October 14, 2009, acquitted some CO accused, it convicted the present appellant. The High Court upheld this conviction, and the Supreme Court has now affirmed those findings. Having perused and appreciated the materials on record, we are of the considered view that no ground for interference is made out in the present appeal, the bench stated. Rejecting the contention regarding the 12-hour delay in filing the FIR, the court held that such delay cannot be said to be fatal, rendering the prosecution case to be doubtful in any manner. The prosecution examined 14 witnesses, including Sukhwinder Singh, the son of the deceased and an eyewitness to the incident. The court took note of the argument that he was an interested witness due to his relationship with the victim, but clarified no doubt he is the son of the deceased, but that itself cannot be a ground for rejecting his testimony. Interested and truthful witnesses are two separate things. A relative may be interested in the eventual success of prosecution but still can be truthful. The bench also found no material on record to doubt his credibility. The witness is wholly reliable. Unrefutably, he has been able to establish the prosecution case of the accused having inflicted injuries on the head of the deceased with a sharp-edged weapon kulari, which was recovered by the police during the course of investigation. The injuries sustained by the deceased were grievous in nature and resulted in her death. Additionally, the husband of the deceased, who was also the complainant and examined as PW3, corroborated the prosecution's version and supported the sequence of events leading to the conviction. Swipe left for next video. The court found no evidence of animosity between the parties and held that this was not a case of sudden provocation or a heat-of-the-moment act. Dismissing the appeal, the court nonetheless granted the appellant liberty to seek remission. We, however, clarify that it shall be open for the appellant, considering the long incarceration, for availing the benefit of remission as framed by the state. We are sure that as and when the appellant would be entitled for the benefits thereunder, the same shall be accorded without any delay. Latest blogs.